This is Bloomberg Law with June Grasso from Bloomberg Radio.
For the first time, a former president has been convicted of felony crimes. A New York jury found Donald Trump guilty of 34 felony counts of falsifying business records to conceal a hush money payment to adult film actress Stormy Daniels in a scheme to illegally influence the 2016 election. After the verdict, Trump repeated his familiar complaints about the case.
This was a disgrace. This was a rigged trial by a conflicted judge who was corrupt. It's a rigged trial, a disgrace. They wouldn't give us a venue change. We were at 5% or 6% in this district, in this area. This was a rigged, disgraceful trial. But the real verdict is going to be November 5th by the people.
Judge Juan Merchan will sentence Trump on July 11th. That's just days before the July 15th Republican National Convention, where the party is set to officially select Trump as its presidential nominee for the November 5th election. Joining me is Bloomberg legal reporter Eric Larson, who covered the trial from start to finish. Eric, what was the reaction, Trump's reaction in the courtroom when this verdict was read?
He did not give much reaction at all other than to have a very stern look on his face, sort of a grimace. You could tell from some of his comments that he seemed to expect this verdict. So he didn't seem to have an expression of surprise or anything like that, but he did have a very stern look on his face when he eventually left the courtroom with his entourage. He did not glance at the many members of the press who were sitting in the courtroom, as he has done so many times during this trial. And then he went out to make his remarks. So there wasn't much of a reaction at all. And actually, the judge said before the jury came out, he did not want to hear or see any reaction from anyone in the courtroom, including Trump would be included in that. So there really wasn't much reaction at all. It was just the sound of everyone typing away on their laptops, and that was it.
It seemed as if the judge said the jury was going to go home at 4:30. Then all of a sudden we heard a verdict. Was everyone shocked that a verdict was coming in so fast?
I would say everyone was taken by surprise, specifically because the judge did say he called everyone into the courtroom, including the parties and their lawyers, all the press, had them seated and said, it's 4:15, I'm going to be sending the jury home. The end time was 4:30. There was the option he would give the jury to stay until 6 if they wanted, but it was unclear if that had ever been suggested to them. He just said he was sending them home. So he stepped away and then came back a few minutes later, and he said, actually, I have a note from the jury, and they have a verdict. So everyone clearly was surprised. There sort of gasps in the courtroom. Everyone obviously, it was mostly press, was rushing to get the news out. And then the judge said that the jury needed an extra 30 minutes to fill out the verdict sheet, which, to be honest, made me wonder if it wasn't a very complicated verdict sheet. Mm-hmm. But everyone just waited, and they eventually came out and read out the verdict.
So, Eric, you sat through the trial. What do you think was the strongest piece of evidence in the case?
I have to say that the testimony of the government star witness, Michael Cohen, had to have had a huge effect on the jury. Even though he was part of the conspiracy, and the judge said that they couldn't, as a result of that, they couldn't find Trump guilty based only on Michael Cohen's words. But had to take it in the context of all the other testimony and all the other evidence, and which really did back up a lot of what Michael Cohen said. And he has a long history of twisting the truth. That was all brought out at the trial. The defense wanted to undermine his credibility at every step. But when it came to the words that he was saying about Trump and his interactions with his former boss, around the time when he was a devoted Trump employee, his fixer, his lawyer, that the jury clearly accepted the things that he was saying about these interactions with these, with the hush money payment, the scheme that was hatched at Trump Tower in 2015 with the publisher of the National Enquirer. All of these details that he gave about the efforts to suppress negative stories about his Trump's conduct with women before the 2016 election, it must have rang true with the jury, and they accepted it.
So now when we look back, I'll put you on the spot for a second. It seemed to me the jury was starting from, ground zero when they asked the judge to start with reading readbacks of David Pecker. Yeah. Then they seemed to go fast forward. So, what do you think they were looking at there?
Well, my theory, which I guess I will never know, but my theory was that all of the counts, 34 counts, they were all very similar, and they all related to the same documents, types of documents, but really they all hinged on one thing. Was there a conspiracy to pay hush money to suppress these stories? Because as we know, the money that was paid ultimately violated election law. They were criminal payments that supported a presidential campaign by benefiting a campaign. And then, of course, the documents were falsified to sort of cover that trail. So it seemed like they wanted to know, was this conspiracy real? How was it hatched? How did they operate under the conspiracy? So they wanted to hear Pecker's and Cohen's testimony about that 25-minute meeting at Trump Tower in August 2015. They wanted to hear again exactly what they said about it and what their understandings were about it. And then they wanted to hear what Pecker said about paying Karen McDougal, the former Playboy model, and also Pecker telling Trump that he should pay to get the Stormy Daniels story out of the press if he could do that. And so it seemed like they wanted to see how Pecker operated under this agreement, how he thought it worked. So if they went back to the deliberation room after hearing all that again and said, well, this conspiracy is real, and so everything else just sort of fell into place. That's my theory, but we may never know.
That's true. I want to just pick up on that for a second. The jury was anonymous. A lot of times after a jury verdict comes in, you'll, as a reporter, you'll see the jurors come out and you can grab them and ask them questions about, how'd you come to this decision, etc. These jurors, what happened? They just disappeared after the verdict?
I don't know what they did after the verdict, because I was stuck in the courtroom as they were, I think, all escorted out. But I can tell you that before the judge dismissed the jury, he did tell them that the strict rules that they've been operating under, preventing them from speaking to the press or anyone else about the trial, are officially lifted. And so he said that they were free to talk to people if they want to. I think it was made crystal clear to this jury as a result of the anonymous nature of it, how unusual that is, that it was all to protect their safety. So I think it's a safe guess that a lot of these jurors probably are going to heed that concern, that warning, and try to keep themselves secret. But I also wouldn't be surprised if one or two of them, jump into the spotlight here. You can imagine there would be some temptation there to grab that spotlight.
So now the judge set a sentencing date already, and it's sort of in line with what would normally happen with someone convicted of a felony about a month from now.
Right. A lot of people were asking me, and I'm sure everyone was asking, do you think that he's going to get sentenced right away? Or, people were full on speculating that he wouldn't be sentenced until after the election and things like that. The judge never really gave a hint that he was the kind of judge who would do that. He really did try to treat Trump like any other defendant to the best of his ability, given the special circumstances with the Secret Service there and everything like that. But you'll recall during the trial, Judge Merchan threatened to throw Trump behind bars during the trial for violating that gag order, preventing Trump from speaking publicly about the jury or the witnesses. So after he violated that twice, or through multiple violations, he was found in contempt twice. The judge said, "I don't care. I'm sorry about your Secret Service and everything else. I know it would be a big problem for everyone and a big inconvenience, but I will put you in jail if you do this one more time." So, Trump didn't do it again. So the judge is, I think, it doesn't surprise me that he would put a sentencing date on the calendar like anyone else.
And the district attorney at the press conference would not say whether or not the prosecutors are going to ask for prison time or not. He said, read it in our filings. We're going to do that the way we do everything else. Eric, I understand that the judge got angry at Todd Blanche after the verdict came in when he made a motion to throw out the verdict and said something about Michael Cohen not being credible and how the jury couldn't base their decision on Michael Cohen.
Right. Blanche had said something along the lines of there's no way that the jury could have come to a conclusion this quickly without relying improperly on Michael Cohen's testimony. The judge just very quickly rejected that. I'm not sure exactly what specifically about that request got the judge to raise his voice a little bit, but I mean, the judge got impatient with Todd Blanche multiple times during the trial. And you know, the lawyers are making arguments with Trump sitting there. Trump is going to expect them to say something, to do something on the fly, and in a way, they're just they're doing what their client wants them to do.
Yeah, I think probably a lot of what we saw at the trial was because Trump was there, and the lawyers had to do certain things. Perhaps even bringing in Robert Costello, who was a defense witness that sort of backfired on the defense.
Right. Mm-hmm. Yeah, that was. I will have to try to get an interview with Blanche soon, and maybe ask him if he'll, say what he thinks about that performance. But Costello clearly caused a bit of a scene, a major scene. And that was Trump's only witness on the defense. So it did kind of backfire. Clearly, the jury didn't take too seriously anything that he said.
And it seemed like there were a couple of instances where Judge Merchan maybe lost his temper, but for the most part, and considering the pressure that he was under, the constant pressure and the constant criticism of Donald Trump outside the courtroom, talking about the fact that the judge was biased just about every day, I think, he was pretty even-keeled, wasn't he, during the trial, from what I understand?
Yeah, 100%. I would say the word unflappable comes to mind, which is why when the judge really sort of lost it with that Robert Costello, that witness, it really sort of shocked everyone. But he has not, he hasn't raised his voice at Trump, which, for example, we saw with Judge Lewis Kaplan in the Eugene Carroll trial. He just was very even-tempered for the most part, and did not seem to take anything personally, at least not that we saw, regarding the things that Trump was saying about him every day right outside the courtroom door. He was just focused on protecting the safety of the jurors and the witnesses. But clearly there will be some people angry with the judge here as well. We've already seen that.
You're listening to a special edition of the Bloomberg Law Show. A historic verdict. A New York jury found Donald Trump guilty of 34 felony counts of falsifying business records to conceal the hush money payment to adult film actress Stormy Daniels to illegally influence the 2016 election. Joining us now is Joshua Naftalis, former federal prosecutor, partner at Pallas. Josh, first of all, just what's your general reaction to the fact that this verdict came in all guilty counts and really within 2 days?
So, I mean, it's obviously historic, but I don't think it's necessarily surprising when a jury comes back this quickly. When I saw the sort of the news flash that there was a verdict, it's got to be a guilty verdict when it comes out quickly. So, I mean, kudos to the government for proving its case.
And Josh, there was a lot of talk from the very beginning about how, this case was concocted to be a felony when it should have been misdemeanors, and how the government sort of made this into a felony. I mean, was it a difficult case to prove?
I mean, it was actually a relatively simple case. I mean, and it was basically about lying on paper, right? That's what the case was about. Now, the motive and the story required telling why he did it and why he knew what he was doing was wrong. But I think, overall, the government, it was strategically kind of brilliant. They took a very complicated fact pattern and turned it into a pretty simple felony story.
How much do you think the testimony of Michael Cohen. I mean, Michael Cohen, before the case was brought, and, there was a lot of talk about how can you bring a case based on the testimony of Michael Cohen. Explain how the prosecutors did that and still got a conviction.
So I was listening to your conversation with your prior guest, and a couple of things occurred to me about Michael Cohen. The first is the difference between state and federal law is if this were in a federal court, a jury could convict solely based on the testimony of Michael Cohen, which is just an interesting difference. And I think since you had to have corroboration about Michael Cohen, my read of what the jury was asking for, you had asked the prior guest about, what were the various requests for readbacks. I think they were looking for corroboration. What happened at Trump Tower? Did what Michael Cohen said line up with the other witnesses? And I think that's obviously why Todd attacked Michael Cohen so heavily in his closing argument. So he was certainly a key witness. And I think, my read is that the jury credited him. That's not to say Michael Cohen is a perfect witness. He's definitely not. He's obviously lied. He's admitted to it. And he's sort of got more baggage than the average cooperating witness. But I think in the end, obviously, he delivered for the government.
Looking at the case, and as I was talking with Eric Larson, the defense presented really one witness. The first witness was about records. So they presented Bob Costello, which seemed to backfire on them. As a defense attorney, what else do you think they could have done to make their case stronger?
When the defense puts on a case, it's very risky because there's one school of thought that says they should have done nothing, right? Which is just get up there and say the government didn't meet its burden. But since they called effectively one substantive witness that imploded, then all of a sudden they've taken on a burden of trying to prove something. And every juror is sitting there wondering, wait, that's all they had to show for it? They didn't have to do anything, but they had one witness. And I think it's obviously very hard to second guess people, but you have to wonder whether in the end it was really worth putting this guy on the stand.
In the closing arguments, the main thing was the attack on Michael Cohen. Also, that Stormy Daniels was lying. How big a mistake was that for the defense to say that Stormy Daniels was lying about the sexual incident with Donald Trump when it seems like just about everybody accepts that that's the truth? Was it a bad move to start out that way in opening statements and say she's lying about that, and then to close with that too?
I agree with you. I mean, I think like everybody has to believe that happened even before she testified. And that must have been a client-driven strategy, which is to deny the fact of the encounter at all. But once again, you take on that burden, the jury's sitting there wondering, the president's claiming that the Stormy Daniels issue didn't happen. So why would we believe the fact that he didn't pay it off in the end? It would have been a little simpler to say, like, yeah, this may have happened. That doesn't mean he had committed a crime. But adultery is one thing, but that doesn't mean he committed the crimes with which he's charged.
What do you do when you take on a client like Donald Trump? Because it seems like a lot of the decisions that the defense made were made because they were playing not only to the jury, but they were also having to play to Donald Trump and what he wanted.
I think that Todd and Emil and Susan did a great job. I mean, with what was the facts were what they were, and they did the best they could. My guess is that had he had different lawyers, less skilled lawyers, it would have been a circus, and they were able to control him in a way that other lawyers could not have. That's not to say that he was an easy client or that the result would have been different, but I think that if there had been less strong lawyers on the defense side, they would have probably done more of what Donald Trump wanted, which would have resulted in sort of more of the outburst that you were talking about with the judge, where the defense lawyer says one thing and the judge says, sit down, not in my courtroom.
Donald Trump has been before about 3, I think, New York judges so far. There was Judge Angoran in the civil case, and then Judge Lewis Kaplan in the E. Jean Carroll case, and now Judge Juan Merchan. I think there's one other that I'm leaving out. But all those judges were different. It seemed like Judge Angoran was a little looser. Judge Kaplan was so strict. And then you had Judge Merchan, who was somewhere in between.
I mean, they were all different postures, right? A criminal case is different. And There are different rules in each one, but I think the pressure under each of these judges was extreme in that you have an unbelievable press sort of attention. You have the president of the United States, the former president, on trial. You want to make sure that he gets a fair trial. And you have a difficult client who's pushing the envelope. I think that the judge did an excellent job. He got this trial in. He didn't lose the jury, meaning like the jurors were able to reach a verdict. There obviously will be an appeal, but he was able to contain what could have been a circus and made it, I think, a model of what everyone wanted, which is the president was held to account, whether however which way you wanted to come out, but a trial occurred and a jury reached a verdict, which was the goal.
There was a lot of controversy from the Trump side about the gag order that the judge put on Trump as far as witnesses in the case. Does that gag order last through the sentencing?
No, I don't know. My guess is that at this point the gag order falls away. I haven't read the gag order with that in mind, but it really was designed not to intimidate witnesses or to infect the jury. Now that the trial's over, there's less of a need for it. Obviously, he doesn't want to bait the judge. I mean, again, the judge is the one who's sentencing him. So if he starts to mouth off on Twitter or attack the judge, then the person who's going to be the ultimate decision maker on the sentence is obviously going to sort of consciously or unconsciously take that into account.
The judge has set a sentencing date for July 11th, which is pretty much along the lines of when you'd set a sentencing date for anyone who was convicted of a felony. And the district attorney wouldn't say whether or not they were going to seek prison time. I mean, what are the chances that Donald Trump will be sentenced to prison time? Remote?
Oh, I'm almost positive he'll get prison time.
You are?
Yeah, the question is whether or when he will serve it. I think the judge will impose a sentence. I don't know how long, but will impose prison time. There will then be a series of appeals that will go on for some time, and I doubt he will be remanded during that time period. But I think sort of the principle that no one is above the law sort of would dictate that you get a prison sentence. That doesn't mean he's going to jail for the rest of his life. The sentence will be what it is, but I think that this judge has made clear that he's prepared to punish Mr. Trump.
Even though, I mean, he's not above the law, but it's his first time, being convicted of anything. He's 77 years old. Also take into account that I'm not sure, and the judge mentioned this during the trial, how the Secret Service would work out in prison. Don't you think that those things might interfere with a prison sentence?
I mean,
I'm just trying to convince you, play devil's advocate.
I hear you. I agree that it's a tough call. I think the judge made clear and the Secret Service made clear that they could deal with this, as awkward as it would be. That's not to say this is going to be a long sentence necessarily, but there's a certain symbolism to it, which is if you don't send someone to jail for a felony, what's the point of prosecuting?
I'll leave it at that. And we'll find out, I guess, on July 11th. Thanks so much, Josh. That's former federal prosecutor Joshua Naftalis. You're listening to a special edition of the Bloomberg Law Show. We're discussing a New York jury this afternoon finding Donald Trump guilty of 34 felony counts of falsifying business records to conceal a hush money payment to adult film actress Stormy Daniels in a scheme to illegally influence the 2016 election. Joining me now is former federal prosecutor Robert Mintz, a partner at McCarter English. Bob, I'm asking everybody, what's your first reaction to hearing that this jury came back with 34 guilty counts?
Well, it was unquestionably a historic moment for this country. The first former U.S. president charged with a crime and now a convicted felon. I was not so much surprised by the verdict, but I was surprised by the swiftness by which this jury came to their conclusion. This was a somewhat complicated case in terms of the jury charge. It was a layered crime in the sense that jurors had to find first that there was a falsification of business records, and then that it was done to commit some other crime, which turned this from a misdemeanor into a felony. In this case, the other crime was to affect the election in some illegal way. And so given all the complexities in the jury instructions and the evidence, I think it was rather shocking that they came back with a verdict unanimous on all 34 counts in only a day and a half of deliberations.
Yeah, the jury instructions, 50 pages, they were very complex. And unlike in federal courts, I mean, the jurors can't take copies of the instructions back with them. So it is kind of amazing that they were able to figure it all out because it was complex. I mean, you had two parts of it that had to be beyond a reasonable doubt, but then you have the unlawful means, which could have been any of three different things.
Yeah, and often in these cases, even when jurors may be inclined to convict, they methodically go through all of the evidence, sort of weighing each count separately, looking at all the evidence that is there presented by the prosecution, considering the defense. And it was surprising that in a case with this level of complexity, the verdict came back so quickly. What it does signal is that there really was no doubt in the minds of these jurors as to the guilt of former President Trump. They obviously viewed the evidence as overwhelming for the prosecution, and there was obviously little dissent among jurors about the outcome of this case.
I mean, I'd love to talk to a juror about this because I'm curious as to how much the closing arguments helped them, because the prosecutor, and they went long and they went late, but he took them through just about every piece of evidence that they needed to find guilt, and in a methodical kind of way. Whereas the defense, which is the way the defense usually is just trying to poke holes in the prosecution's case.
Yeah, that's right. I mean, the defense strategy was ultimately to try to raise reasonable doubt, and to try to raise reasonable doubt in the minds of even one juror, because a hung jury where there is not unanimity on any one count of the indictment is essentially a win for the defense. It means the prosecutors can try the case again, but the individual is not convicted. So here I agree with you. I think the prosecution did a very good job. They took an awful long time, but I think it was worth the time they put in there because they did take these jurors through every step of this case, witness by witness. In the New York State courts, unlike in federal court where prosecutors go first and then the defense goes and then prosecutors get a rebuttal, in New York State court, the defense goes first and then prosecutors have the last word. So the closing statements here for prosecutors was really a combination of rebuttal of what the defense presented and also presenting their own closing arguments. And that's probably why it took so long. But it was very thorough and apparently very effective in terms of convincing these jurors that this was really an open and shut case. This
really presented a unique test of the legal system because Trump was a former president. You have that. And his relentless attacks, verbal attacks on the case, the judge, the DA. Describe how, if you're the prosecutor in the case or you're the judge in this case, how that adds to your sort of difficulty, or I'm going to say agita.
Yeah, well, certainly there have been other high-profile criminal prosecutions, O.J. Simpson, lots of others that were very high-profile, but we've never really seen one where the defendant had the kind of platform that former President Trump has every day to step outside of that courtroom and to reach millions of Americans commenting on the case, commenting on the strength of the evidence, commenting on the witnesses, the judge, the prosecutors, challenging them all along the way. And that's something the prosecutors, as you say, do not typically face. The question, though, ultimately is, did that make its way to the jury in any way? Did that have any impact on any of the witnesses? And I guess we can conclude that it did not because of the swiftness with which this verdict was returned.
Jurors are always told, you can't look at news, you can't do this, you can't do that. And jurors often don't listen to those. You find out later that they don't listen to all the different admonitions that the judge gives them. In this case, it would have been hard for them to avoid hearing about, over 5 weeks, to avoid hearing things about the trial, don't you think?
Oh, I agree with that. And I think even leading up to the trial, before these 12 individuals were even sitting on this jury, there was obviously an enormous amount of publicity about this trial. And there were statements made by former President Trump about the case, even though he was admonished by the judge and there were gag orders in place. But there was an awful lot that was out there that they no doubt were exposed to. and yet they were instructed to put all of that aside and to make a decision based solely upon the evidence that was presented to them during the trial by the defense, by the prosecutor, and to follow the instructions of the judge as to the law. And ultimately, that's what they appear to do here. There's no evidence that they listened to information outside the jury room. If that comes to light, that creates certainly an issue for the defense to take up on appeal, if not sooner. But at this point, it appears that jurors did what they were supposed to do. They followed the rules and they did their job, and they ultimately found that there was overwhelming evidence of guilt in this case.
So the system worked, yet we're going to hear over and over from Trump that the system didn't work. What do you think about appellate issues? I assume one is going to be the change of venue, because today when he got out of the court, he started talking about the fact that the judge denied a change of venue.
Oh, yeah. Well, there's a host of issues that I think we'll see raised on appeal. Some of them perhaps have more merit than others, but there was that motion for a change of venue, as you say. That was predicated on the idea that Manhattan voted overwhelmingly for President Biden, didn't vote for President Trump. I don't think that's really a fruitful argument. I don't think you can show that the jury pool was infected or was in any way biased simply because you didn't vote for somebody for president. That doesn't necessarily mean that you can't have an open mind in terms of how you view them in a criminal case, but they're going to raise that issue, and they're going to point out that there was so much pretrial publicity here. But again, that would be the case pretty much anywhere in the United States, no matter where you went. And if you think about it logically, also, if you moved it out of Manhattan to an area that another part of the country, that area might have voted for former President Trump. Then you sort of have the opposite situation. And so it was not surprising to me at all that the judge denied that motion. But there are other issues. Certainly the fact that this was a unique and somewhat novel application of the law, the way that Alvin Bragg charged this case. It had really never been done before. There's no appellate rulings on the way he turned the misdemeanors into felonies here by relying on an allegation that the cover-up was really the essence of this crime. In other words, false documents were created. That's the business record crime. That's the misdemeanor. But what turns into a felony is that it was done for the purpose of committing another crime, and that is to influence the election. There's not a lot of case law on that, and I think we can expect the defense to raise that as a major issue on their appeal.
Bob, we discussed when the jury was selected the fact that, surprise, surprise, there was not only one, but two jurors who were lawyers. Plus, you had, I think, 3 MBAs and someone with a doctorate. This was a really smart jury. Advantage prosecution?
Well, that was, to me, always sort of the open question. As a lawyer and as a prosecutor, and even as a defense lawyer, you really don't want a lawyer sitting on your jury, let alone 2 of them, because they do have the ability to sort of overwhelm the rest of the jurors because jurors will defer to them. You don't really know what their views are. You really want it to be a level playing field where everybody has the same voice. But in this case, both the defense and the prosecutors were willing to have these 2 jurors sit on this jury. And at the end of the day, they both, I guess, decided that an educated jury, one that paid close attention to all of the details, somebody that was steeped in the law, even though neither of these lawyers were criminal lawyers, but they were lawyers. They understood the way the law worked. And I guess both prosecutors and the defense thought that that might be an advantage to their side.
Is there anything you think the defense could have done to change this verdict, or the evidence was overwhelming?
I think it was a very tough case for the defense. They did a pretty good job of beating up on Michael Cohen. They showed that he had lied before, that he had lied repeatedly. They showed that he had a financial motive in order to provide this testimony. They showed that he had a personal vendetta against former President Trump. You really can't score any more points than they did with Michael Cohen. But at the end of the day, prosecutors did a good job of bolstering and corroborating his testimony with other evidence. And one of the things prosecutors did, I think, very effectively is that they relied on witnesses who were clearly still in the Trump camp. People who worked for former President Trump may not have been still close to him, like Hope Hicks, but somebody who was still loyal to him, and yet they were able to elicit testimony that was damaging to the defense and helpful for prosecutors from witnesses who who had no bias against former President Trump whatsoever. That was compelling testimony, and I think jurors sat up and paid attention when those witnesses testified.
You're listening to a special edition of the Bloomberg Law Show as we cover the historic verdict. Former President Donald Trump guilty of 34 felonies. So, Bob, I just talked to Joshua Naftalis, who I'm sure you're familiar with. He said he thinks that Donald Trump is going to be sentenced to prison. What's your take on that?
Well, obviously, that is now the big question, now that the conviction has come in and all eyes turn to the judge here for sentencing. Typically, in a case like this, you might not expect a jail sentence, but this is not a typical case. As a case that is obviously very high profile, it was enormously covered by the media. There was enormous attention paid really throughout the world. And I think the judge is going to be hard-pressed to only sentence former President Trump to probation in this case. So I do think there will be some type of jail sentence here, although I think it will be minimal, more symbolic than really punitive because of the circumstance of a former president and putting him in jail. I also think it's likely that the judge will stay that sentence of incarceration if he, in fact, imposes that to allow the appeal to go forward. So at the time of the election, we won't have a situation where former President Trump is actually sitting in jail. Typically, in New York State, the sentence comes about a month after the conviction, and if there's jail imposed, usually that begins almost immediately. But the judge does have the discretion to allow the defendant to remain on bail pending appeal, which I think is likely the scenario we'll see here.
And just explain that this is a state conviction, so what that means if Donald Trump becomes president.
Sure. So of all the cases that are out there, and there are several, as you know, there are a number of federal prosecutions pending, one in the District of Columbia involving January 6th. There's the document destruction case down in Florida. Those are federal cases that ultimately a president can pardon somebody who's convicted of a federal crime. Whether a president can pardon himself is untested, but certainly something that former President Trump could do if he were to be elected president again. But state crimes, such as the one in Atlanta and this one, a president cannot pardon themselves. So he has no control whatsoever in terms of removing this conviction, of overturning it, simply because he becomes president. The only way to overturn this conviction will be on appeal, and they'll have to convince the Court of Appeals that there was some type of reversible error that was committed here to either throw the case out or send it back for a retrial if they're able to convince the Court of Appeals that those types of errors occurred here.
Is this a vindication for Alvin Bragg and all the abuse he took, at least in the media and from Republicans, about bringing this case, a case that was based on misdemeanors, and then he bumped it up, as you explained before, to felonies. And, at the press conference, I remember when he brought this, they kept asking him over and over and over, what's the underlying crime? And he didn't say, and we didn't learn until we saw the jury instructions, really.
Well, he did keep that very close to the vest, but I think they did a good job of trying to convince jurors that this was not a case about record keeping. It was a case about election interference. And you heard prosecutors actually say during closing arguments that this crime might have, because they could not simply say categorically what the outcome would have been, but they said that it might have actually affected the outcome of the election. In other words, if the Stormy Daniels story had broken just days before the election, after the Access Hollywood tapes and everything going on there, could it have affected the outcome? Could the outcome of the presidential election been different? That was their theme, because they were trying to convince jurors that this was a really important case. This was not simply a bookkeeping case, a clerical error, simply calling something illegal, engagement letter, a payment of a legal retainer, when it was really something else. They wanted to show the real significance here, and that's why they spent so much time talking about what was going on in the Trump campaign, the impact of that Access Hollywood tape where he was recorded making comments about grabbing women, and the free fall that the campaign was in at that time, and how significant it would have been if this story had come out. So they did a very good job of selling that story to jurors and convincing them that this was really an important case.
And Alvin Bragg played this much differently from what the New York Attorney General Letitia James did in the case where New York was recovering money from the Trump organization. So she would come out every day almost in response to Trump's statements on the courthouse steps. She would make statements on the courthouse steps. But Bragg didn't make any statements at all. He was in the courtroom a few times, but nothing to the press. And then tonight, it was a very low-key kind of press conference, and he didn't answer the questions that people were, firing at him about whether they were going to see jail time, etc. Is that the difference between a criminal and a civil case, or is that just different personalities?
I think that's really just a question of different styles, and you're absolutely right that the Manhattan DA was incredibly understated at the press conference after the conviction. He almost tried to make it sound like this was just another day in the office. While this was an important case, he cited a couple other important cases his office had recently handled, and he was really trying to convey that this case was nothing special in terms of how it was handled by this office. It was straight down the middle. The fact that it was a former president, that it was historic, none of that ultimately affected how the case was prosecuted, how the charges were brought, and how it was ultimately handled. And I think that was an effective strategy. The prosecutors and the Manhattan DA himself let all of their talking take place in the courtroom and did not engage in any of the theatrics and the hyperbole that we saw from former President Trump. And as you say, the Attorney General, Letitia James, in the civil case. So it really tried to downplay the circus atmosphere and focus the public on what was going on inside the courtroom, which ultimately I think was an effective strategy.
Thanks so much, Bob. As always, a pleasure having you on. That's former federal prosecutor Robert Mintz of McCarter English. Well, we're going to continue with our coverage of the Donald Trump verdict. We are covering a jury verdict late this afternoon, which found Donald Trump guilty of 34 felony counts. Joining us now is someone who was in the courtroom for the entire trial, Patricia Hurtado, Bloomberg legal reporter. So, Pat, did you think it would happen so fast? I mean, we've talked almost every day about this case, and it seemed like a verdict was far away.
Well, from the way the defense was talking, they delivered closing arguments. And I thought it was really interesting yesterday that the jury had asked for testimony between David Pecker and Michael Cohen. And the defense lawyer, Todd Blanche, had argued in closing to the jury that Cohen had completely contradicted Pecker. But if you actually listen to the readback of the testimony we heard this morning, it became really clear that he didn't at all. That they had corroborated each other. It seemed then the jury got quiet for quite some time. And then this afternoon, suddenly, half of the courtroom lost their internet. So when the verdict was being announced, half of us did not have any ability to cover it, because it went down. Whether it was jammed or it was an accident, I don't know, but it was quite heart-stopping. But it gave me the ability to really stop and look at everybody. And to hear that first count, guilty, and then hear for 4 straight minutes, 34 counts of guilty, 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 guilty being uttered, it was just unbelievable, like a wave. And then we heard cheers from outside the courthouse. We're on the 15th floor, but it seemed that the word had gotten filtered out to news crews outside, and there were cheers from people out in the park that had gathered to hear it. So it was quite a historic moment.
Did the jurors look at Donald Trump when they were reading that?
They filed in, and they did not make eye contact with him when they walked in, which is to me always a tip-off. And then as they were looking, most of them were looking down, but they polled the jury, and it was unanimous.
Donald Trump heard this. It seemed to me like from his statements outside the courthouse that he was sort of prepared for this. I mean, the other day he said that, it would take Mother Teresa to beat these charges. Well, I mean, I did speak to my colleague photographers. I mean, we were locked in the courtroom. We're not allowed to move if Trump is moving for his security concerns. But my colleague photographers captured some astounding images of his trial team looking completely shattered and shocked
including Melina Hava, his lawyer, with her jaw dropping open. And some of the court officers looked stricken. It was an amazing thing, and they said that Trump seemed to be fumbling to try to figure out what to say. As he walked out of the courtroom, he sat stone-faced as the verdict was announced and looked straight ahead, and then he got up, and it looked like, when his face was just fury. And then he turned around and he fist bumped his son, Eric Trump, who was sitting right behind him, and then he basically strode down the center aisle of the courtroom and walked out to make his statement. But it was not the kind of forceful thing you typically expect from Donald Trump. No. So, he might have been prepared that he was possibly expecting a guilty verdict.
Yeah, it was very much similar to things that he's been saying, basically every day, every other day. What about the prosecutors? Were they smiling at least?
Yes, there were huge grins from the prosecutors like Josh Steinglass, who spent 5 hours on Tuesday trying to convince the jury and going through all the massive evidence. He called it a mountain of evidence. Matthew Colangelo, who was a former federal prosecutor who had done a masterful job of openings, he had a huge grin. And Susan Hoffinger, who came to join Bragg's team as a criminal defense lawyer, she came back as a prosecutor. She had done an amazing cross-examination of Robert Costello, who was Trump's witness. And they all had huge grins on their faces.
You know better than anyone, having covered this so long, the sort of abuse that Alvin Bragg has taken for bringing this case and for having Michael Cohen as the star witness. And yet, right after, he really didn't gloat or anything. He just was very, very straightforward about the case.
Alvin Bragg has a reputation. I was listening to Rob Mintz there. He has a reputation of being a very circumspect person. He's not a dynamic speaker at all. And I think under the law, in criminal cases, they're different from Tish James. So she can go out and have a press conference. But under criminal law, prosecutors have to be much more careful of what they're saying on the courthouse steps. And they cannot basically try their case on the steps of the courthouse. They have to limit their statements to what's going on in court. Alvin Bragg is a practitioner of that to the nth degree. But he did seem very happy. And he was basically saying that, well, they've had massive fights and battles to reach this day. A jury has ultimately spoken. And now we've arrived at this trial, and ultimately this verdict is in the same manner that any other case is brought in this courthouse. But even if it's historic, it was treated just the way the office has always handled white-collar crime.
He also didn't say whether or not the prosecutors would be seeking prison time for Donald Trump. Do you have any insight into that?
Well, he can ask. Under the law, it's anywhere from 1 1/3 to 4 years for each count. I understand it would not be added, stamped together, and all of them linked together and added up to, let's say 70 years in prison or whatever. It would be consecutive, so they would all be concurrent, so they would all merge together. Whether or not a first-time offender who's Trump's age faces prison is another matter. I don't know what Judge Merchan's going to do, and Alvin Bragg wouldn't say what he's going to do, but he said he would limit his statements and his comments about what he's going to do about Donald Trump to the court and to court filings.
Stay with us, Patty. Joining us now is former federal prosecutor Michael Zeldin. Michael, I've asked everyone, because this is the question on a lot of people's minds, whether or not you think Donald Trump will be sentenced to some time in prison.
I don't think you should. If you want to keep the system working according to the, sort of structure of it, a person with his past record should be put on probation. Now, he's a former political official, and sometimes it's important to make these politically exposed persons held accountable to a higher standard. And if the judge thinks that's appropriate, then I would think a period of house arrest could be important message to be sent to other public officials. But going to Rikers Island or someplace like that, I'd be very surprised.
Judge Merchan maybe deserves an award for his ability to take this case through to the end and not lose his temper too many times. I mean, it was a tough case to preside over. He encountered so many obstacles day after day that you wouldn't encounter in a normal trial.
Well, you encounter them in high publicity trials. We saw that in the Judge Ito failure in the O.J. Simpson case. I think we saw it to a certain extent in the Judge Erdogan trial for the Letitia James case. I think both of those judges, on a sliding scale, didn't do as well as this judge. I think this judge handled himself professionally, did not take the bait ever, protected the judicial personnel and other family members of them appropriately, and I think he gave a sober recitation of what the criminal justice system should look like.
Pat, tell us about the judge's sort of performance here, I'll say.
The judge has been extremely careful and cautious. He's a very mild-mannered guy. He never loses his temper. I've made the joke to you, June, that most of us would love to have a husband like that because he never loses his temper. He is, and he has been challenged. I think the magnanimity of the import of what he has to do in this case has always weighed heavily on him, and he takes it extremely seriously. So he's not a kind of guy like Judge Engoron who used to make jokes and be very jocular and make, goof around. He is just a very serious person. So, I mean, and he's been challenged by Trump, as has Alvin Bragg, and has that trial team. They've had death threats. So, and Judge Merchan's daughter was threatened. So, and we all need to remember that Donald Trump had promised death and destruction if he got indicted, and that's what happened. So here we are a year later, and everybody's had to deal with this historic case with a historic defendant that doesn't act like most defendants.
Yeah, and Michael, I mean, we didn't hear from the jurors so far. I'm not sure if we will hear from the jurors because of, the way that at least part of the country has reacted to Donald Trump being prosecuted.
If I were a juror, I would be quiet. I don't see any value to them individually in speaking forward. Now, the news networks, of course, are going to be doing everything they can to get their first big scoop of the juror to talk about what happened in the jury room. But I think we'd be better off, and they individually would be better off, if we just let it be as it is now.
Patty, what do you think? Book deals? I mean, there's a lot that a juror could do here.
It was stunning to me that prospective jurors walked out of the courthouse after being dismissed and saying they were too frightened to be on the jury, and then they walked in front of the TV cameras and gave interviews. That always shocks me. I've also, as a veteran court reporter, have covered hundreds of trials where the jurors will say, "Oh, sorry, no interviews," including Ghislaine Maxwell's juror that later came forward and said that he had cried when he left the courthouse. And I actually doorstopped him as he walked out of the Manhattan Federal Courthouse and said, "Would you like to comment?" And he basically ran away from me. So I'm always kind of surprised when I see people, but I guess when they want to get their 15 minutes of fame, some people are very tempted. I personally kind of think in this case, Trump will look for every angle to challenge this. So I kind of agree there with my colleague that I don't know if it's such a good idea, especially for someone like Donald Trump who wants to, and his followers. So I don't know. They want to proceed as.
And the judge spoke to the jurors after the verdict was handed down, Patty?
Yes, and he thanked them for their service, and he said things like, this was an amazing job you guys did, and it was historic, and what you've done is you've paid all this attention, and you've. He wanted to thank them personally, so he asked them, and he said, "I can't get into details of the case, but I also just want to thank you personally." And, we also had other jurors reach verdicts on, we had two other juries reach verdicts on Donald Trump in New York City. We had two Manhattan federal juries in the E. Jean Carroll case, and they were both deemed anonymous by the federal judge in that case. So it kind of, I don't know, that's the practice in federal court, but He said, you were engaged in a very stressful and difficult task, and I want you to know that I really admire your dedication and hard work. You're free to discuss this case with anyone, and you're free to not discuss it. The choice is yours.
How long do you think before we see appellate papers here?
I understand under New York state law, I talked to two criminal defense lawyers, or veteran criminal defense lawyers in New York, and they said that under the law in New York, a defendant cannot start their appeal until after they're sentenced, because they're technically in this weird limbo awaiting sentence. So Donald Trump has to wait till at least July to file those papers. That's not going to mean he's not going to try it. And his lawyers did today, after the verdict, Todd Blanche stood and asked for an acquittal, saying that Michael Cohen was completely unbelievable. And the judge firmly rejected it. Going on to what Mershon has said about prison, he has warned Trump that he had to obey the gag order, or else he might have to imprison him. And he called it basically it was like a last resort that he didn't want to do for his pretrial.
Yeah.
Whether or not he does it, he said to the jury when the defense lawyer mentioned don't send him to prison on these charges, that was a call for a curative instruction. And the judge told the jury this verdict may not result in prison.
We'll have to leave it there. That's the big question going forward. Thank you both. Patricia Hurtado, Bloomberg legal reporter, and Michael Zeldin, former federal prosecutor. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.